is not relevant.
And a camera captures the total picture.
I just couldn't take it anymore because he was cursing at me and yelling at me.
That, sir, is not a demonstration of someone who's in fear.
This is Judge Judy. Aviram Kavan is suing his condominium neighbor, Alan Hanft, for legal fees and punitive damages for filing a false restraining order.
Judge, this is case number 138 on the calendar in the matter of Kavan versus Hanft. Parties have been sworn in. Have a seat, sir.
Mr. Kavan, you and the defendant are neighbors in an apartment building.
A condo building, Your Honor.
According to your complaint, you share a penthouse with Mr. Hanft.
He's my next-door neighbor.
The problem between the two of you arose when you were doing a renovation. Were you doing a renovation when you first moved into your apartment?
No, Your Honor, I've lived in the building for 6 years now. I started my renovations in November of 2019, so 1 year ago.
How long, Mr. Hanft, have you lived in that building?
Since 2015.
So you moved in after the plaintiff moved in?
Yes, Your Honor.
Who do you live there with?
I live by myself. I have a dog.
And Mr. Kavan, who do you live with?
I live by myself. I also have a dog.
You were doing. You and the defendant had no difficulty.
Correct, Your Honor.
I assume, Mr. Hanft, that prior to this renovation, you and the plaintiff had no difficulty.
No.
And prior to the renovation and the discussion about the balcony and the awning, you had no fear of him.
No, but I do now, and I have for several months.
But just a second. Just to answer my questions.
I've always been a little bit afraid of his pit bull, and it's been roaming in the hallway more at times since this all started.
Well, before this all started, did you ever discuss with him that his dog was roaming in the halls?
I told him I'm afraid of it, and he just laughed.
You mean before?
Before and during.
Okay. At some point in the renovation, Mr. Kavan, you approached the defendant and said to him that as part of the renovation, you no longer wanted an awning covering your balcony. And you asked the defendant if you could take it down. He said no. And according to you, you took down the covering that covered your part of the balcony. Do you have pictures of that awning before you took it down?
Yes, I do.
I'm going to look at them.
Please, yeah.
When you took it down, the defendant clearly complained to the Homeowners Association, and you were reprimanded for taking down the awning without written permission.
Absolutely.
So,
Okay,
which sort of forms the genesis of this case?
From the inside view of before the awning, if you see where this divider is here.
So it's a solid awning.
It's an aluminum solid awning from dating back from 1963, I think, maybe.
And certainly you understand that that's a fixture part of the building, and that in order to remove that, which I assume all the balconies have that are penthouses, there are only 2 penthouse apartments?
No, so there's 9 penthouse apartments. I was not the first to remove it. In fact, someone else has already removed it.
Point is, you took off the awning, and they didn't make you put it back up, and it's still off.
Absolutely.
That's actually not what the case is about, but it's sort of the genesis of the difficulty.
Yeah,
between you
it stemmed
and
from
Mr.
here.
And so you did take the awning down. The defendant was upset about that. According to his cross-complaint, he began to feel nervous around you because you had words with each other. And he filed a protective order against you, the basis of which was ridiculous, according to you, and forced you to spend close to $5,000 in counsel fees to defend that lawsuit, which ultimately was either dismissed or withdrawn by the defendant. So it's really not about the awning. It's really about the protective order.
Correct.
Your says that after this awning incident, they developed a course of conduct that he found harassing and threatening, and that's why he filed for a protective order. I don't know what happened to the protective order. He's going to tell me. But, Mr. Hanft, since really the whole issue is up to you to convince me that you had a reasonable basis to file for a protective order, I'm going to start with you. The first thing is I want you to show me a copy of the complaint that you filed, and then I have questions for you. Great. Now I want you to tell me, Mr. Hanft, in what month and year did the plaintiff take down the awning over his apartment?
He took it down November 13th, I believe, 2019. And the awning issue is not the point of this, but it's not resolved either.
Now, the awning issue precipitated the difficulty between the two of you,
Yes, Your Honor.
which formed the basis for your application for a protective order.
Yes.
Which forms the basis of his claim that you filed a false protective order.
It
that
was
cost him a
totally
lot of
not
money.
false,
So what
Your
I
Honor.
want you, just a second. That's why we're here, sir. You have to understand two things. Conduct by someone against whom you filed a protective order has to be such that a reasonably prudent person would understand that this was threatening behavior. If you threaten, but there is no overt demonstration of threatening behavior that a reasonable person would view as threatening behavior, that a court considers when they consider whether the filing of a protective order is real or not. So now we're going to go back to November 13th, 2019, which is the incident that precipitated this bad feeling, and tell me the first incident that you allege, and you don't allege any of these things. You don't allege anywhere that he assaulted you.
Physically,
correct?
no.
So protective order covers conduct that is assaultive, menacing, threatening, or harassing. That's the criteria usually for protective orders.
I would say it was more harassing.
Fine. And so if you characterize, so didn't assault you, didn't menace you, didn't threaten you.
I think he said things that I felt threatened by him and behaved in a way that I felt threatened.
Well, no. Well, how you felt is not relevant. If the behavior itself did not rise to the level of what a reasonable person under the circumstance would find threatening behavior. So
he
let's
would yell
go back.
at me and curse at me in my private.
No.
It actually started in August when he was approaching me. He wanted me to say that I wanted to take down the roof. And I started off I preferred to have the roof, the sun protection, and the rain protection. And he just kept asking me, and I kept explaining it politely, but he wouldn't take no for an answer. So he started, badgering me, telling me it has to come down.
No. Listen, Mr. Haft. You're looking over to the side. What I want you to do is look at me. Badgering is a conclusory term. I want you to tell me what he did. The fact that you found it badgering is not particularly relevant. So he kept asking you to put your hand down. Give me a specific date where he said or did an act that was threatening.
May 9th, he said that he had enough of me. He's tired of taking it easy on me. He called me this, he called me that. He said it in a very hostile way. I found it frightening. I didn't want to pass him to go home. Then when I started to take my phone out of my pocket because it was so horrible and just frightening and upsetting and just a terrible experience, this is so bad I want to try to record it because it's awful. And then he amazingly immediately just stopped. Then I go, well, why aren't you cursing at me anymore? Why did you stop cursing at me now that I have my phone out? And you were just cursing at me like 9 seconds ago. He goes, tell me what I said. I want to hear you say it. And then he called me like an idiot and a child. And this was the first time I said this to him. And after months and months of being fearful of him, I said, look, I can't take this anymore in my own home. If you don't stop harassing me and abusing me, you're going to have to explain this to the police or a judge or somebody because I can't take it. And he goes, shut up. Get your judge. Get your police. And then he left. And I also want to say one thing. He'd been confronting me and following me around and jumping out of his apartment, jumping in the elevator. I'd be walking my dog in front of the building, and he would just be standing like this, like just staring daggers at me. I wouldn't even want to return home. I wouldn't want to even leave my apartment. And in this whole time, Your Honor, that this was going on, I was proud of myself. I either spoke to him politely, or if I saw him coming after it got bad, I would walk in the other way. I never showed any emotion. This was the only time that I ever showed any emotion. I showed it to my friends when I would tell them what's been happening to me, but the only emotion that I ever expressed in front of him about this horrible stuff that he was doing was that time, because I just couldn't take it anymore because he was cursing at me and yelling at me, and it was just so awful and so horrible. In my own home, I didn't want to walk out of my car parked in the building. I feel sick to my stomach because he's going to confront me and harass me. And it's very, very unpleasant, and that should not be how it is in somebody's home, Your Honor, is what I believe.
All right, Mr. Haft, now I want you to just stifle it for a moment. And what I find interesting about what you told me is if he stopped doing what he was doing, cursing you and calling you names when you went to take out your phone, and instead of going into your apartment, you said to him, why did you stop cursing at me? Why don't you say the same words that you were saying before when I have my phone out?
That was the first time I ever had an emotional response.
Just a second. I'm just letting you know. That, sir, is not a demonstration of someone who's in fear.
Judge Judy continues in a moment.
If I was afraid of somebody, I wouldn't say to them, come on, talk into the phone like you were talking before, because I would have darted into my apartment.
I couldn't get by him.
No, that's not true. You're making that up.
Aviram Kavan says condominium neighbor Alan Hanft filed a false restraining order after they had a disagreement over a shared awning. Alan, an infliction of emotional distress.
Okay, if I was afraid of a neighbor.
That was the one and only time I ever said anything to him like that.
It doesn't matter. You're not paying attention to what I'm saying to you. If I was afraid of somebody because they were yelling and cursing at me and took out my phone and the person stopped and backed off, I wouldn't say to them, come on, talk into the phone like you were talking before, because I would have darted into my apartment if I was afraid.
I couldn't get by him.
If I was afraid. No, that's not true. You're making that up.
No, I'm not.
There had to be something before May 9th. So I want you to show me the emails that you sent to the Homeowners Association about the plaintiff.
Your Honor, while he's looking for that, can I just mention that the incident that he's just mentioned was all caught on CCTV. I actually had it subpoenaed.
Do you have it?
It should be available on the monitor.
Oh, yeah, I'd like to see it.
There is no audio.
That was the only time in
now
like
I'm reading.
12 months that I
Just
spoke
a second.
back to him.
Right. I'm reading something. So this was January of 2020. Preventing me from leaving the service. Okay. Now, was this the first time, Mr. Haft, you had complained about the plaintiff's dog?
No. Here's when October 20.
Okay, and that was October of 2019. Mr. Kavan, now each time around this time, were you contacted by the board, Mr. Kavan?
I've had numerous issues with the board. I used to actually be on the board for 2 years. I was voted on for 2 years. So one of the members of the HOA I had some issues with, mainly...
She called the police on him. She was afraid.
I want to tell you something. If you do that again, sir, I'm going to dismiss your counterclaim. Do you understand? Yes. Because it's a demonstration of behavior that is odd, Mr. Haft. Now, each time a letter was sent leading up to May 9th of this year or May 8th of this year, each time a letter was sent, were you contacted by the board?
No.
Did you ever receive any communication from the board?
I have, not with regard to my neighbor, just mainly the awning.
Were you fined for removing the awning?
Yes, it's actually still ongoing. It's over $10,000.
Okay, this is how I'm going to summarize all of the underlying action that I have to know before I get to my final questioning of you, Mr. Haft. Prior to you deciding to ask for forgiveness rather than permission, that you clearly had to know you needed as a former board member, Mr. Kavan, to remove the awning. You removed it anyway, and that clearly created bad, based upon what the defendant says, after he complained and made a pest of himself, became a nudnik to the board. Clearly, you were annoyed with him. He was certainly annoyed that you had removed this top balcony, and a situation developed that he felt that the recourse that he had was to file a protective order against you. I don't know what he was asking for. It's not particularly relevant because the protective order was ultimately dismissed. So now I have several questions for you, Mr. Haft. Do you still live in the building or have you moved? That's either I still live there or I moved. That's either I still live there or I moved.
I still live there.
And I want you to tell me, what date did you file for the protective order? Just give me the month, day, and year.
June 23rd of this year, Your Honor.
When was the case either tried or dismissed?
It was going to be tried on August 15th, but he asked for a continuance.
I don't know whether you're purposely trying, if you're purposely trying to get on my nerves.
No.
Judge Judy continues in a moment.
You do not deny the statement that the plaintiff has not lived in the building since the gut renovation started. You fully believe it.
Real cases, real people. Judge Judy. Aviram Kavan says condo neighbor Alan Hanft filed a false restraining order after they had a disagreement over a shared awning.
Okay, I want to know on what date the case was either tried or dismissed.
September 25th.
Did you withdraw the protective order on September 25th or
Yes.
24th? Now I would like to see the video of the May 8th incident.
You know, that door is the freight elevator door.
Got it. Okay.
Since the renovation started, it's been a complete teardown, so it's been completely uninhabitable. So anytime I've been there, it's
So you have
really...
not been in the building since your renovation started?
Well, I would obviously come to check up on the workers.
But you haven't lived there?
No, I've barely been there.
Do you have a paid invoice from your attorney?
I do.
I'd like to see it. You do not deny the statement, Mr. Hanft, that the plaintiff has not lived in the building since the gut renovation started.
I don't know where he's lived.
Okay, fully believe me. 4875. Mr. Hanft, your counterclaim is dismissed for harassment. I am awarding the plaintiff the counsel fees that he's requested, $4,875.
There was one extra bill.
From whom?
I had to retrieve footage. I had to get subpoena for the footage, and the building charged me.
Just a second. All right. Well, that brings your claim to over $5,000. That's the maximum that I can award you, sir.
Okay.
There are several things, Mr. Hanft. When you have a neighbor that you're unhappy with, there are several things that you do. One of the things that you don't do when they are no longer physically your neighbor is you don't file for a protective order and you withdraw it when it was ready to go to trial. And some arbitrator like me could have looked at that footage and said, who looks like the person who is more aggressive. Aggressive conduct and body language that I saw was yours, right from the beginning.
Judge Judy continues in a moment. Closed captioning sponsored by... Are you the victim of an assault? Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
Okay, he's not living there anymore. He should have not taken the steps that he did in renovating his apartment without HOA approval. That is clear. I do not condone that. And there are consequences to that. And he hasn't lived in his place.
He was there a lot,
Consequences,
though.
I'm sure that
I
there will be.
see him all the time.
Just a second. I'm not talking to you anymore. Now I'm issuing a judgment. And the judgment that I'm issuing is that you're going to pay his counsel fees. If he had counsel fees of almost $5,000, sir, you had no business in on the eve of trial. After forcing him to pay $5,000, you withdrew the case. I don't see why you withdraw the case. Maybe your attorney had the footage. Anyway, your counterclaim is dismissed. Judgment for the plaintiff in the amount of $5,000. We're finished. Thank you very much.
Thank you, Your Honor.
This case is concluded. Parties are excused.
And on the next Judge Judy...
Either you lied to me today or you lied to the Better Business Bureau.
That was a mistake I made.
It's always a mistake when you get caught.
Your Honor.
Judy.
I was not comfortable returning home or opening my door.
Alan has been a complete nightmare of a neighbor.
And I'm only human. I showed some emotion on that one time in the entire year.
He enjoys playing the victim. He's neurotic.
I'd like him to stay away from me and leave me alone.
I would like to go separate ways, and hopefully we'll be happy again at some point.
A fitness instructor's questionable technique.
The agreement was I would collect payment at the end of the classes.
That's not a way to do business.
I thought I could trust her.
Now,
We never completed the sessions.
logic gets a workout.
What justification is there for you not to pay her any money?
She was late. Half the classes weren't even 2 hours.
She probably doesn't understand what she's trying to say.
This is Judge Judy. Zumba instructor Taylor Coco Patterson is suing former student Nikki Herrera for the cost of classes.
Judge's case number 94 on the calendar in the matter of Patterson versus Herrera. The parties have been sworn in, Your Honor.
Ms. Patterson, you allege that you had a contract with the defendant, and that contract provided that private dance classes that you were going to provide her. Those dance classes were Zumba classes. That's a very active form of dancing that's really athletic. I tried it once. I wasn't very good at it, but I am familiar with it. How long have you been a Zumba instructor?
For approximately 5 years.
Do you give private lessons as well as lessons for groups?
Yes.
Ms. Herrera, how did you find Ms. Patterson? Who referred you to her?
I actually found her on Instagram. A few people I saw on my timeline had already booked her, and so I just reached out to them.
In what month and year did you reach out to her?
It was January of 2020.
How far away does she live from you?
About 2 hours.
It's a 2-hour drive.
With traffic, yes.
What was the contract you made with her?
So the contract that I made with Taylor was actually for 10 Zumba private classes for the $2,000.
When were they supposed to start?
January 30th of 2020.
Was that a weekend or a weekday?
It was a weekday. Our first class was a weekday.
So you had a round trip of 4 hours on that day?
Correct.
So you went to the first class?
I did.
Did you go to a second class?
Yes, ma'am.
On what date?
I can't remember the exact date, but it was supposed to be on Thursdays and Saturdays.
What was the second date she went for a class, Ms. Patterson?
Well, the first date was January 30th. The second date would have been Saturday, February the 1st, 2020.
So she went one day right after another?
No, it wasn't going to be like that. It was like 2 days a week, typically Thursdays and Saturdays, because those were days that we agreed upon that we would both be available.
Did she attend the class on February 1st?
Yes.
And there were supposed to be 10 of these classes for $2,000. Is that right?
Yes, 2-hour classes, 10 2-hour classes, yes.
Now, you had never met her before, so could you explain to me, as somebody who's been in the business for 4 or 5 years, and since you never met her before, could you explain to me why you didn't, as people usually do in this kind of business when they do classes, you want to take 10 classes, great, it's $2,000. You pay up front and then you eat off whatever it is. You not only didn't ask for any money up front, but she didn't even pay you when she came, at least the first 2 classes. You want to explain that to me?
Yes, because the agreement was, number one, the first reason is she was referred by a longtime client of mine.
Well, that's what you say. That's not what she says. She says that she found you through Instagram.
Through a client of
that
mine.
You may have.
So a client that
That's not what she said.
Well, she probably doesn't understand her to me. So she may have reached out to that human being. That human being reached out to me and then vouched for her as a person that I should work with. So that's how I got the referral. So that's number one. Number two.
Well, she says she got you via Instagram.
But Instagram is
and
like
she
friends.
Got you via
you have
Instagram
friends
from
on Instagram.
somebody.
Yeah.
I understand that. I understand that. So she found it on her Instagram. Somebody that she knew had taken classes from you. That person contacted you.
Yes.
And that's how you got together.
Yes.
Okay. But she found you on Instagram.
Through a friend, through a mutual friend.
Another person who she was
friends with,
connected to on Instagram.
Who had taken my classes.
You don't necessarily have to be a friend to somebody who's on Instagram. You know, people have 967 people.
Right.
I think I know 967 people in my whole life that I would send a photograph to.
Try 30,000. Anyway,
do you want to try to explain to me why you didn't take any money from her the first 2 classes?
Because the agreement was that I would collect payment at the end of the classes. And, you know, me being...
But that's not a way to do business. Nobody does business like that in the training business. No trainer comes in and says, you do your class.
I do. I have worked with trainers before who I have not paid up front, who it might not have been the wisest decision. Hindsight is 20/20 vision, you know, but it was the decision I made. I was trying to be friendly, jovial. You know, I thought I could trust her. I have other people who have paid in this same exact manner. I had no problems collecting payment. The classes are worth it. They were good. So the person who referred her was someone I also trusted. So I thought it would be okay this time around.
What's the name of the person who referred you?
Summer.
Summer what?
I only know her first name is Summer. She's not someone I wouldn't know her last name. Instagram is typically Instagram name, first name, but she's my client.
She said she was a very good client of yours.
She was, but I know her as Summer.
You say in your complaint she was referred to me
By a longtime client.
By a longtime client.
Yes. But
whose last name you don't know?
No, you know how many people I know I don't know their last names. No. I'm sorry.
Well, if you look on your phone, how would you list Summer if she was a longtime client, if you had to get in touch with her?
Summer Bunny.
So find it in your phone.
It's on my Instagram.
Well, your Instagram is also on your phone.
Right, but what do you want me to do?
Well, if she was a longtime client, let me ask you this question, madam. If you want me to fully understand you.
Okay.
If you had a longtime client whose name was Summer, whose last name you don't know.
Right.
But you got sick and you had to call them or notice sick, as you were sick a couple of times when she was supposed to take classes, how would you get in touch with Summer?
Two ways.
You sent her a photograph of you in bed?
No, I could do that with Instagram, but I would text her on Instagram. I would send her a DM on Instagram and let her know that I wasn't feeling well and I wasn't going to be able to make it. And that's how I would reach her. And she might not reply back.
All I want you to do is take out your phone.
Yes.
And show me on Instagram show me, text Summer. And show me that goes through on Instagram. I'm here doing a case with a person you referred to me. I just would like to see it.
No worries.
To Summer.
Oh, here she is. So should I sit it here?
Yes, please.
All right. So I'm going to sit my phone here. So unfortunately, you're going to see other messages I've sent to Summer. But this is her profile.
Great. Okay. Now that you've found this, can you find me possibly where you have any communication about the defendant with Summer?
Oh, no, we had verbal conversations. Like at the end of a class, I spoke with her and she mentioned her to me. And also by way of just phone call.
Phone call?
Yeah, phone call or either a class.
Phone call. Well, also a
But she and I, you know, we were doing a class together. No, we were her.
Okay. How many classes in total prior to the pandemic did Miss Herrera take from you?
Well, the pandemic happened in March. So I would say 8. Approximately we complete, no, not approximate, but 8 classes.
Is that correct? How many round trips did you make to her house?
I took 7 classes. She missed the last 3.
No, I missed 2.
It was 3.
I missed 2.
She missed the last 3.
Okay. Did you pay her for those classes?
No.
Why?
Well, I was supposed to pay her at the end of our session, our 10 sessions. We never completed the sessions to even do that. She just sent me an invoice.
So you don't think that because you took 7 2-hour classes with her, you have any responsibility to pay her?
No, because they weren't even the full classes. She was late. Half the classes weren't even 2 hours. And she didn't, so I don't understand why am I paying for classes that weren't complete?
You have a piece of paper there.
Mm-hmm.
What is that piece of paper?
These are my notes.
What are those 2 pieces of paper?
These are my notes, and this is the invoice. And then one of our text messages that I found. I have a new phone and number, so this was just the last that I had.
Okay. I'd like to see the invoice she sent you. What is that? That is a nothing. Take that away. That's a nothing that somebody made up. Okay. Now let me see the text message. What is this? I'm staying that Friday, leaving on Saturday. Is those messages from her?
So this is my message here. This first message, she missed a lot of...
I'll be there Friday.
Correct. She missed she missed classes, and she was supposed to, let me know when we can make them up. So I was messaging her, letting her know I was going to be in her city this day, but I was not staying. And so I just let her know I was going to be here to see if maybe we can, get together for a class. And she said yes, but it just took her forever to respond.
Unless you need me. Delayed response. I'm preparing for you. Yes, we can get together Saturday Afternoon. Also, what about your friend? What's the friend?
She asked me a while back if I knew anyone who did hair, and I sent her the person's name or whatever, and that was it. But they didn't respond back to her, so I think that's what she was responding, like, what happened to your friend? But I called her because it takes her forever to even respond to me.
Judge Judy continues in a moment.
I just feel like I came to her classes. I'm driving 2 hours. Half the time, she's late to every class. Why am I paying you for a class and you're not even giving?
And later today.
Why don't you sue him? He sold the salon.
Because I have no idea where...
He sold the salon.
I have no idea where he is.
That's not my problem.
Zumba instructor Taylor Coco Patterson claims former student Nikki Herrera owes for classes.
Okay, I'm going to take your figure that you took 7 classes. It still means that you owe her $1,400. How can you not pay her anything? What justification do you have? And this is the end of February when you've already taken, according to you, most, if not all, of the classes that you took. What justification is there for you not to pay her any money?
Okay, first and foremost, Your Honor, I just feel like I came to her classes. I'm driving 2 hours. We get there, half the time she's late to every class. The class is only 2 hours. Why am I paying you for a class, a full class, and you're not even giving me the full
So why
hours?
didn't you just say, I'm not coming anymore?
Well, I did later on.
Why didn't you just say, I'm not coming anymore? I'm not making a 4-hour trip if you're going to be late.
Well, Your Honor, that's kind of why I kind of just stopped, going to the classes, the last few classes.
Well, that's okay, but then you stop and you pay her. You don't stop and don't pay her.
So I'm going to pay her for classes.
It makes perfect sense to me. If you took the class, if you said to her, sorry, you're a half-hour late, and if you say it happened the first time she was a half-hour late and I had driven 2 hours to get there, I would say, this is not working out for me. I'm going to pay you for the class that I took or the 2 classes that I took, but I'm not coming back here. I'm not making a 4-hour round trip if you're going to be disrespectful of my time and come a half-hour late.
I've spoke to her.
And you spoke to her, but you continued to come. You're ridiculous.
I mean, I figured she would change
pay
up
for the classes. I'm not giving you the $2,000 that you want. I don't think you're entitled to money that you didn't earn, but you did do some work.
I did work.
$1,400 cover the hourly?
Yes.
$1,400. Judgment for the plaintiff. We're done. Thank you.
Thank you.
This case is concluded. Parties are excused.
I don't agree with it, but I respect it.
I could have done a better job about collecting payment up front.
It is what it is. I just know not to do business with her again.
She wanted to work on the booty. She wanted to get her booty right.
I had a young man, so I was trying to get my groove back.
Money up front from now on out. You can't trust anyone.
All parties in the matter of Ernst Palmer versus Trivedi Abus Yunus. Step to the podium, please.
Joyette Ernst Palmer is suing Ravi Trivedi and Rabi Abu Yunus for property left behind at a salon they purchased.
Ernst Palmer?
Yes.
In a tanning salon. And you had your own tanning salon piece of equipment.
Yes, I was a mobile service, and this was the first time I was working out of a salon.
And you brought your machine to a salon.
Correct.
They had nothing to do with the salon that you brought your machine to. Who was the owner of the salon that you brought your machine to?
The owner was Asfer. It was under previous ownership when I was originally hired back in May of 2019.
Okay. Now, at some point, you agreed to sell your mobile unit to Mr. Asfar.
Correct.
For $1,000.
Yes, ma'am.
When did you make that agreement with Mr. Asfar?
I made it on January 21st of 2020.
And he paid you for the unit, according to your complaint, $660.
Correct, in increments.
And Mr. Asfar had a balance of $340.
Correct.
That he owed you.
Yes.
On the machine.
Yes, ma'am.
And then you were whole. And then Mr. Asfar sold the salon to these 2 gentlemen.
Correct.
That was when? When did you purchase the salon? Month and year?
February 6th, 2020.
When they purchased the salon, did you advise them that the piece of equipment...
Yes, I did.
Is that correct?
No, that's not correct.
Did she at any time tell you that she had a prior agreement with the prior owner to purchase the salon?
No, we were not aware of any prior agreement whatsoever.
That's not true, Your Honor.
Okay, so when did you have a conversation with either one of the two defendants?
I spoke with Robbie. It was in March because I was still waiting for the rest of the money from Mr. Asfor. And I told him I'm still owed $340 for my equipment.
So why don't you, just a second, why don't you sue him? He sold the salon.
Because I have no idea where...
He sold the salon. Whether you had...
I have no idea where he is.
Well,
my personal stuff...
That's not my problem.
Judge Judy continues in a moment.
Did you have a lawyer?
It went through my CPA.
So your accountant had to speak to the seller's representative. Just say yes or no.
Yes,
Don't shake your head. This is audio-visual.
Real cases, real people. Judge Judy. Joyette Erst-Palmer claims Ravi Trivedi and Ravi Abu Yunus owe for a tanning machine and personal property left behind at a salon they purchased. She is also suing for lost wages.
Stop. No.
They have it in the salon. He wouldn't let me take it.
No, listen to me. Because COVID struck, he got rid of all the towels and robes and that stuff that was in the shop. He purchased the shop. Listen, there's no question that they have a contract that they're going to show me. Is that correct? That you purchased the shop and all the stuff in the shop?
That's correct.
You want to put that up there? Good. Just point to the area in the purchase agreement where you purchase everything that's in the salon.
Yes. So we have the excluded liabilities and assumed liabilities.
Oh, well, that's an interesting thing. So, Mr. Erst-Palmer.
Yes.
Your lawsuit is against Mr. Asfor, not the defendants. You've been paid $660 for your tanning machine on a $1,000 purchase price. Mr. Asfor owes you $340.
Correct.
Not the defendants.
Along with they have my stuff, though, in the salon. I never agreed to sell my personal stuff, just the machine.
Just for my own information, what personal stuff are you talking about?
I brought 2 sheets with me. I brought hair accessories.
I'm not interested in sheets. Not interested in your hair accessories. What's next? Come on.
That is my
You're being
personal
foolish
stuff
with me.
that is my personal stuff that I purchased and I brought from home.
Do you have any of that stuff? Do you have 2 sheets and hair accessories?
It
They
was
don't
never
have it.
there.
What's next? Just a second. I don't care. I just want to know if you. I'm just asking if you have her 2 sheets and her hair accessories. I would say if you have them, give them back to her. What else? You're suing the wrong people for your tanning machine. You have to find and sue Mr. Asfor, and maybe they can even help you locate him because they paid him $33,000. So you paid $33,000 for the business?
Yes, ma'am.
So I'm sure you have a bank account that you had to pay the money to, unless you paid him in cash. Did you pay him in cash?
We paid via the cashier's check.
Did you have a lawyer on this sale of the business? Did you have a lawyer?
It went through my CPA. We didn't go through the lawyer.
Fine, so you have an accountant.
Yes, ma'am.
So your accountant had to speak to the seller's representative. Just say yes or no.
Yes,
Don't shake
ma'am.
your head.
Yes,
This is, audio-visual.
Judge Judy continues in a moment. Closed captioning sponsored by... Want justice? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Okay. I'm directing you to make available to the plaintiff any information that you have that will enable her to locate Mr. Astor. Do you understand?
That's correct. We do have his driving license and it has his address. She could reach out.
Perfect.
Excuse me, Your Honor.
That's perfect. What do you want?
They have all my stuff, and I lost wages. I had clients calling.
We're done. They don't owe you a thing. Mr. Asfor owes you $340. Find him. They're going to give you his driver's license. We're finished.
What about my other stuff that's there? If they don't have it, don't they owe me?
No, they owe you nothing.
I'm not owed the money to
They owe you
repurchase?
Nothing. They owe you nothing. They don't owe you for your 2 sheets or your hair accessories. We're finished.
This case is concluded. Parties are excused.
And on the next Judge Judy, a party planner didn't pay her bills.
I never received a billing.
We're not going to be able to come to a resolution in this case unless we cut out the baloney.
Next Judge Judy.
I think it was straight to the point and justice was served.
I will be contacting the previous owner.
Get ready to back to business. Yes, please.
Time to get back to business.
A The wife finally had enough.
Does your husband have a lawyer in the divorce?
He don't even know I'm filing for the divorce.
You were living with your son and his wife?
Yes.
Stands behind her son.
Your Honor, she's not filing for a divorce. She haven't filed for the divorce, and she's not.
I will, as soon as I get home. I left the house due to domestic violence.
This is Judge Judy. Calvina Zeno is suing her estranged mother-in-law, Regina Marzette, for the value of a Samsung tablet and unauthorized charges made on a joint bank account.
Judge's case number 99 on the calendar in the matter of Zeno versus Marzette. Parties have been sworn in.
Miss Zeno, you are still currently married to the defendant's son.
Yes.
When were you married?
2007.
When did you and the defendant's son separate?
About 2 years ago.
Did you move out or did he move out?
I left the house due to domestic violence.
It's your claim that you left behind a tablet, a Samsung tablet, and that the defendant at one point said she didn't have it, but then she did in fact have it and used it once, according to you. Where is the tablet now?
She has it.
Did you find her tablet?
I had seen it. She had left the tablet there. I never used it or have it. And she came back to the house 3 or 4 times.
Where is it?
I believe it got stolen. My son had left it outside on the gate to go in the apartment, and he came back in with them.
Okay. She doesn't have your tablet.
I never used it.
From 2 years ago. Now, you have a counterclaim. Your counterclaim is money owed for credit card charges.
Yes.
I assume these credit card charges were made prior to 2018, were made when you were living with your son and his wife?
Yes. We had it was around 2016. I let her start using it, put on the authorized user, and we had agreement. As long as she paid it, I didn't care what she used it for or whatever. As long as she made monthly payments on it. And May of this year, she stopped making payment. Then she made 2 more payments, though. She stopped because I used it. We also had a bank account together, Wells Fargo, and I accidentally used it charged my DMV $35, and so she closed the account, and I didn't know until I tried to use it, and then I texted her saying the account is closed. She said, yeah, I closed it because you made $35 charge on it and went over her account.
We're not getting involved in this.
Okay, that's when she stopped, and then she
fiasco that happened in 2018.
But she was making payments up to this year, and then I'm telling you the reason why she stopped it first. Because I used the card that she was making the payment up for with the credit card payment with, and the account went over, and she closed the account. And then, but then
do you have a lawyer in the divorce?
No, I'm the one that's filing for the divorce. I have to turn in my paperwork. He don't even know I'm filing for the divorce.
Okay.
I haven't spoken with him since I left.
Okay. Does your husband work?
I'm not sure. I don't communicate with him anymore.
Your mother-in-law says that you had an individual agreement with her to use a credit card prior to 2018. What was that credit card used for?
The card was used for her son charges. I also made charges on the card. I used it for my guard card, which I believe is paid off. Like she said, I've been paying it since the card been on there, but our card got towed a few times. Security guard card, license.
Okay, and how much was that for the guard license?
I want to say about $800.
And you've been making payments since 2018 of how much a month on the card?
$150.
Do you have the credit card receipts or the bills that show how much she was making payments on? I'd like to take a look at them.
I'd like to show you this. This one I stop her from using it, showing the balance. When I stop her from authorized user because when it went over $5,000.
Who else is an authorized user on that card?
No one else. I didn't even use it, Your Honor. I make no charges on it.
Prior to 2018?
I have never used that, Your Honor, used the card. Not even me.
Do you have a card?
I have other cards. That's why I only set that aside for her to use, for I wouldn't have no disagreement with the charges.
Tell me what you used the card for before 2018.
All I can remember is using it for is my guard card and to get the cars towed out because he kept getting our cars towed. So we had these, she said, for emergencies, and we used it to get it towed out, but I continue to make the payments. That's why I don't understand why she's saying that it went over $5,000. Last time I seen it was at $4,800, and that was years ago.
Your Honor,
I don't understand. I never seen the statement, so I have no clue what's on there. I don't know who used the card.
I have statements she used it for her car insurance, monthly.
Just a second. On September 17th, did you pay a Progressive Insurance bill?
No, all my car insurance bills was paid on my bank account.
I don't have Progressive, Your Honor. This is all her charges and the wireless
What year did you
phone.
say was it, ma'am?
September 17th.
2008. This 2000.
Did you pay?
In 2018?
Yes, it was 2008.
No, in 2020.
No, this is 2018 right here. This one she was
I'm not, listen to me. This is a marital debt. These bills were accrued prior to the time that your son and
But our agreement was, I had agreement with her. As long as she paid.
Marital debt. Some judge, when she files for divorce, is going to determine whether this credit card.
Your Honor, she's not filing for a divorce. She
hasn't
haven't filed for the divorce, and she's not.
I have the paperwork at home.
She's not.
Well, I think that you should do that.
I will.
Because.
As soon as I get home.
Because I'm dismissing her counterclaim without prejudice. You have to file for a divorce so a judge can determine how much of this bill is a marital debt and whether your husband, her son, is responsible for any part of that bill. Like if a car was towed and it was his responsibility, but it was paid for on this card. I don't know, and I have absolutely zero interest in finding out. Because when you file for divorce, one of the things that a judge will do is look at the equities of the parties and what they have and say this car payment, this bank account, this credit card bill, this is either marital property or individual property. And if those charges were made prior to 2018, some judge in a matrimonial part is going to determine that they're marital property, marital debt, which means that your son may be responsible for some, all, or none of that debt. Do you understand? Okay.
Yes, but...
Well, I understand. And I'm the only one who has to understand. Goodbye.
Please are excused.
To build up her credit.
She wanted to help me build my credit.
She didn't have credit at the time.
I wasn't the only one to make the charges on the card.
I still love her, but she went on with her life, so I let her be.
It's time to file them divorce papers.
All parties in the matter of Lyons versus Munoz. Step to the podium, please.
Phillips Lyons Jr. is suing his former landlord, Inez Munoz, and her daughter, Roxana Munoz, for wrongful eviction, the return of his security deposit, and damaged property.
Mr. Lyons, you were a tenant of the defendants for 3 years.
Yes.
And you had a security deposit of $1,400.
Yes.
With the defendant. Your complaint seeks the return of the entire security deposit. She already sent you $500. She retained $900 of the security deposit.
Yes.
In addition, you're asking for other money for a whole lot of nonsense. Damaged property as a result of a pipe burst in February of 2020. You didn't move out until July. I assume the damaged property that you're referring to is the damaged property as a result of the pipe bursting.
No.
What damaged property as a result of what?
The roof leaking. There was heavy rainfall at the end of 2019, beginning of this year, that ruined. There was water throughout the house, damaging the furnace.
Okay, I get Mr. Lyons, understand this, sir. You're a renter. If there's a leak or a burst pipe and your stuff is damaged, that's what renter's insurance is for. That's what homeowner's insurance is for. Yeah. That's not what this nonsense is. That's why I'm saying there's a whole bunch of stuff here that's nonsense. You want the return of your security deposit. You also put in a claim here for wrongful eviction. But I read your complaint, and I read in your complaint that you gave her a 30-day notice on July 21st.
Yes.
You gave her notice. She didn't evict you. You gave her notice that you were moving out. Where did you move to?
Long Beach.
Who did you move in with?
My witness.
Good. And had you been planning on making that move? Is that why you gave her a notice on July 21st?
Yes.
That you were moving in with a new roommate? Yes, so she didn't evict you.
Judge Judy continues in a moment.
Is that all your junk out there? Sir.
The property damage,
Is
yes.
that all your junk out there?
Yes.
That's not property damage stuff. That's stuff you didn't want. There's a broom there. That's ridiculous.
Phillips Lyons Jr. is suing his former landlord, Inez Munoz, and her daughter, Roxana, the return of his security deposit and damaged property.
Okay. Now let's talk about the return of the security deposit. Then the burden's on her. You had $1,400 of his security deposit. You returned $500. It's your responsibility to show me photographs of why you retained $900 of his security deposit.
Okay, $200 for the trash that was left in the curb. I have pictures.
Oh, so you have pictures and a bill or a receipt?
Yes.
For who you paid to get rid of it?
Yes.
Good. I'd like to see the photographs and the bill.
Is that okay? The next one?
Yes, well, that's not $200 worth of trash.
There. Yes.
Is that all your junk out there, sir?
The property damage,
Is that all your junk out there?
Yes.
That's not property damage stuff. That's stuff you didn't want. There's a broom there. That's ridiculous. Okay, so $200. Can I see the bill for removing all that trash?
There's going to be 2 bills, okay, for the cleaning.
Yes, I'd like to see them both. That says cleanup.
Yeah, it's $200 for the cleaning the curb and $200 to clean the apartment.
Okay, so $200 for clean inside the apartment. What are you alleging was wrong inside the apartment? So you do understand you owe her. She rightfully withheld $200 so far for cleaning up the trash that you left outside.
I don't
Well,
agree
I'm telling
to that.
you, you do. Okay. I don't care whether you agree to it or not. That's your trash to get rid of, not somebody else's. What is that?
Okay, these are the boxes, the refrigerator boxes where you keep your vegetables. That's one of them. Fungus.
Okay, what else?
This is the kitchen counter.
Well, I don't know what is on there.
What
are you showing me?
There's stains.
The stains, I don't know if you can see, it's a yellow, very deep yellow.
Very sticky, but lack of cleaning.
What else?
This is the drawer in the bathroom.
What color is it? Is it
This
white?
one is, the shelf is black, but this is a white stuff.
Stains. There's stains on the black.
What else? Did you take pictures, Mr. Lyons, of when you left the house?
Yes.
Did you take photographs? May I see them, please? Don't show me anymore. What is that?
Those are the pictures of the mold and whatnot growing in the bedroom.
No, I just want,
like that.
I want to see, sir. Is this how you left the apartment? I just want to see if you left it clean. I'm not looking at your mold. I'm finished with your mold. Get homeowners and the inside pretty clean.
And that's one.
Go ahead. Keep going. Is that when you left, sir?
Yes.
Go ahead. What are you showing me?
Of the kitchen cabinets. That's just one of the kitchen cabinets.
If they were cleaned out?
Mm-hmm. They were clean. There wasn't anything in them. That's the bathroom.
Okay. Got it. All right, Mr. Lyons, I don't have to see anymore. Okay. When Mr. Lyons left, he left in... Did you leave in August, sir?
August 1st.
You left August 1st. When did you re-rent the apartment?
September 3rd. It took me a month to clean.
No, it didn't take you a month to clean.
No, not to clean.
You have to clean.
Repair.
He was living there for... No. Sorry.
Judge Judy continues in a moment.
Listen to me, sir. She didn't wrongfully evict you. You gave her notice. You had a kerfuffle about the date because you were sleeping. You don't get up until 2 o'clock. Then she called you. She wanted her rent. I'm not interested.
And later today.
You say I abandoned them. I was just miserable with humiliation, so I left them there.
Well, who would want those things back after she had been with some other guy and
I don't know. Maybe I wouldn't, but maybe Bird would.
Judge Judy. Phillips Lyons Jr. is suing his former landlord, Inez Munoz, and her daughter, Roxana Munoz, for wrongful eviction, the return of his security deposit, and damaged property.
Okay. He left August 1st. You paid $200 to take away his trash, which you shouldn't have left there. That's really your job, to hire somebody to take away all your garbage.
I did. She had told me that when she took those pictures and stuff of the place and the trash, she's like, these needs to be cleaned up. And she's like, you need to come back after she had wrongfully evicted us. And I had told her, I was like...
She didn't wrongfully evict you.
Well, the agreement was for us to be out on the 21st. And on the...
I don't... Listen to me, sir. She didn't wrongfully evict you. You gave her notice. You had a kerfuffle about the date because you were sleeping. You don't get up until 2 o'clock, according to you, to go to work. And she called you. She wanted her rent. I'm not interested.
I have a proof.
I just asked you about the trash that you left behind. I'm just asking you, are you telling me that you paid to have it taken away?
Yes, I had it arranged. I had the city to come on that same week to come get it. And Roxanne knows about this because I had told her, said, okay. And then she's like, no, I'm not waiting that long. And then she got it taken care of herself.
Yeah,
and I had let her know via text.
I don't blame her. I don't blame her. So far, you're entitled. She paid $200 to have somebody clean up that junk that you left outside. The apartment looked pretty clean to me. And if you were lucky enough to have the apartment vacant only for 1 month, and Mr. Lyons was living there for 3 years, you have to paint the place anyway. You have to get it into shape. You can't rent it again right away. You know that.
Right.
Ridiculous. Okay, judgment for the plaintiff in the amount of $700. We're finished.
Your Honor?
Thank you.
Your Honor?
We are finito.
This case is concluded. Parties are excused.
Got sick because of the mold.
The way it was delivered to them and the way it was delivered back.
We told her about it, and she told us to clean it ourselves.
Not to be nice anymore.
Not to be so nice. They always paid late.
And now, the next case.
All parties in the matter of Lauder versus Draper. Step forward.
Amy Lauder is suing her ex-boyfriend, Chris Draper, for an unpaid loan to get his truck fixed.
Miss Lauder, you claim that the defendant owes you for the balance of a loan to repair his truck.
Yes, Your Honor.
Tell me about that.
Back in July, at the end of July, his truck broke down and he needed to...
That would be July of 2012.
Yes. He needed money to repair it and he didn't have money. So he asked me to loan him $900 so he could fix his truck. And he promised...
And why would he ask you to make a loan to him?
He knew that I'd gotten money. My mom passed away, and so he asked me if he could borrow that money.
Were you dating at the time?
At the time I loaned him the money, we were not dating.
When had you stopped dating?
We'd broken up at the beginning of July of 2012.
On what date did you ask her for this money?
I'd never asked her for the
Are
money.
your hands in your pockets?
Yeah. She offered me the money.
No. You can't offer somebody money unless they know that you need money. Listen to me, I want you to follow. If I called Bird and we're talking and I say, you know, I have this truck that needs repair and I don't have any money, and Bird says to me, oh, I can help you out with that. That's understandable. But somehow it has to be communicated to Bird that my truck broke down.
Judge Judy continues in a moment. Closed captioning sponsored by... Have you been cheated? Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
Now, did you receive a call from the truck company?
No, ma'am.
So you received a call from the truck company at your house?
No, I was at her house when it was on my cell phone.
So you were at her house when you got a call and you say, bring, hello, right, got it.
I said, oh no, what am I going to do? I need some money. She's like, I'll give you money.
Oh, great.
I borrowed him $900.
No, you didn't borrow him
Loaned
anything.
him $900, and he paid me back $100.
Okay, good. Now we have a counterclaim, so that takes care of the $800 that you owe her. Now you have a counterclaim, and you said, I purchased a washing machine, a couch, a recliner, a TV, and a desk, and I didn't take these items with me because I just left the house. So
we had broken up.
Just a second, you said you left, and you said, I didn't take these items with me because I just left the house we shared after humiliation I endured when I found out that she had been cheating on me for almost a year. So what are you countersuing for?
For the things that I left at her house.
You say, I abandoned them. That's what you're saying in here. I left them there because I was just miserable with humiliation, so I left them there a year ago.
Well, who would want those things back after she had been with some other guy? And
I don't know. Maybe I wouldn't, but maybe Bird would. Judgment for the plaintiff in the amount of $800. Your counterclaim's dismissed. Goodbye.
You may step out.
Judge Judy continues in a moment. And on the next Judge Judy. Made to move in the middle of the virus.
I didn't evict anyone. I put a pay or vacate, which is different from eviction.
Judy.
That's fine. I'm good with what she said.
I think it was fair, and I'm happy it's over with.
We both work at the IRS, and, we got to be professional, and so this isn't professional at all.
I don't